A UK-based NGO known as the Death Penalty Project said it played a role in helping Bertil Fox, Kemba Swanston, and Patrice Matthew being released from prison. All three men were clients of the Death Penalty Project, a legal action NGO based in the UK. A press release issued by the Death Penalty Project on Wednesday quoted Saul Lefferand, co-executive director of the organization. Mr. Lefferand said, "As lawyers, it is our role to ensure that all those we represent are afforded their statutory rights and that due process is upheld. All applications appealing the sentences of our clients follow standard judicial protocol, and in this case, the decision to release was fairly granted in accordance with the guidelines and procedures of St. Kitts and Nevis' Mercy Board. As an organization, we support efforts to ensure effective reviews of long-term sentenced prisoners and clearly defined for indeterminate sentence prisoners from the prison estate." The Death Penalty Project said, under the Constitution of St. Kitts and Nevis, the Governor-General is able to pardon a prisoner, reduce their sentence, or remit all or part of their punishment. This power vested in the Governor-General is called the prerogative of mercy. The law requires that the superintendent of the prison pass on details of prisoners to the minister who are eligible to be considered for release. Therefore, the final decision rests with the minister to bring attention to a case, the organization said. It continued that the Mercy Board is a committee made up of the designated minister, the Attorney General, and 3 or 4 other members appointed by the Governor-General, all who can advise the Governor-General, yet there is no obligation to adhere to such advice. The Mercy Board must consider a person for release under the following conditions: those who have served 10 years of their sentence prior to attaining the age of 60, or those who have served 15 years of their sentence. Additional considerations for a prisoner's release under the prerogative of mercy includes the mental and bodily condition of prisoners, as well as the effect of the imprisonment on their health, demeanor, and attitude towards crime in general. The failure to consider a person for release on these grounds amounts to a breach of their statutory rights, the Death Penalty Project said. The organization continued, all prisoners are eligible to be considered for release by the Mercy Board, and in the case of Mr. Matthew and Mr. Fox, an application was made to the High Court to review their sentences. The cases were ultimately referred to the Mercy Board, who granted their immediate release, and that of Mr. Swanston. At the time of the release, Mr. Fox had served 24 years, Mr. Swanston had served approximately 16 years, and Mr. Matthew had served approximately 20 years in prison. It is important to note, the organization said, that the Mercy Board regulates its own procedure and that there is no published guidance that the Mercy Board must adhere to when reaching their decision on the release of prisoners. The Mercy Board could have sought the views of the victims and their families. However, in this instance, it elected not to do so. Any decision to include the victim's family in the discussion was within the discretion of the Governor-General and does not obstruct the legal requirements of decision-making, the Death Penalty Project said in their release. The Death Penalty Project is a legal action NGO with a special consultative status before the United Nations Economic and Social Council. According to the release, it uses the law to protect prisoners facing execution and promote fair criminal justice systems where the rights of all people are respected. There was much controversy over the release of the men and the pardon granted to them on the recommendation of the Mercy Board. Mr. Fox, in particular, was pardoned for the murder of 2 women in 1997, and that decision has angered family members of the victims and the wider St. Kitts Nevis society. I'm Andre Huey for SKN Newsline.